Welcome back. We are still talking about real estate law for paralegals, Chapter 1, Introduction to Real Property Law. This is Part 2. We're going to talk about acquiring title to real property. So in Part 1, remember we learned what property was, right? That it's everything that's subject to ownership, that when we talk about ownership, we're talking about the rights that we have in the things that we own. Looked at the different characteristics of property, right? Tangible versus intangible, real versus personal, and then we learned about fixtures. So we looked at different types of property and talked about our rights in those things. So when we talk about rights in property and owning property and the rights that we own, we're really just talking about ownership, right? So when we say ownership, we're talking about our ownership rights in property. And in real estate, when we talk about ownership, we're going to use a term called title. Um, and it's a term that you're going to hear throughout the course and throughout your career as a paralegal. Um, title. And when we talk about title, we're talking about ownership, right? Because title is the right to or ownership in land. And so the terms are interchangeable and you should get comfortable with just using either or. So when we're talking about title, we're talking about ownership, we're talking about ownership, we're talking about title. So as I go through the course, I'll say one or the other whenever I'm talking and just know that they're all one and the same. So when it comes to ownership of things, how do we acquire ownership in property, and more specifically, real property? Well, the first one you're probably going to think of is purchase, right? It's the simple and most common. You exchange something of value for real estate. All right, so how does that work? So let's say we have the Smiths and they find a home that they want to buy. And we have the Johnsons who are selling the home. They want to go retire somewhere. Well, the Smiths have a bag of money and the Johnsons have the deed to the property. So they exchange them and purchase the house. When this happens, someone sells and buys a home, right? The seller is known as the grantor, right? They are conveying or transferring the ownership of the real property. And the buyer is known as the grantee, right? They are receiving ownership of real property. Now, these two terms are critical to an understanding of real estate because the terms are going to be used throughout the course in multiple documents. They're very significant. You absolutely need to know them. So remember, grantor, grantee. We'll look at them later on in the course, obviously, but just know that they're important and let that sink in now. Okay, so the Johnsons want to sell the property, the Smiths want to buy the property. They exchange money for the deed. All right, now the Smiths own the home and Johnsons have a pile of money. The Smiths get to have nice family dinners in the new home, and the Johnsons take their pile of money and retire on the beach, right? That is a purchase where you exchange money for the home. Another way to acquire title or ownership in real property is by gift. So we should all know what a gift is, right? Your book says it's bestowing a benefit without the expectation on the part of a giver to receive something in return, and the absence of any obligation on the part of the receiver to do anything in return, right? So you don't expect anything when you give someone a gift, or at least you shouldn't. And then you don't expect to have to give anybody anything in return if someone gives you a gift, or at least you shouldn't, because then it's not really a gift. It's, an exchange of something for value. A gift is, just given out of the kindness of your heart for nothing in return. So there's many occasions to give a gift, right? You could give a gift for a birthday. You could give a gift for a wedding. Maybe give a gift for graduation. You could give a gift to avoid some taxes. Then you might give a gift for some religious or whatever holiday. Um, all right, sometimes this gift can be property. If you have property to give as a gift, if you can do that, it's the same as, a $50 bill and a Christmas card. It's a gift, right? You can do that with property. So some people do actually acquire their ownership that way. Next, we're going to talk about devise. When we say devise, that is the transfer of ownership of real property by will. So someone leaves the property to someone else in their will. And in case you don't know what a will is, that is a document that represents the formal declaration of a person's last wishes uh, on how their property is to be distributed at their death. All right, so everything that you own at your death, if you have a will, you tell the courts how to divvy it up to everybody. So how does a will work, right? So you're still alive and you want to make sure that you give all the property that you have to those that you love and care about before you go, right? So what do? You draw up a will and you tell the world what you want to do with all your personal property. What are you going to do with that mansion and Ferrari that you have? Well, in your will, you determine who's going to get that property. And so since you want to take care of all your loved ones, you designate who that's going to. That could be the nurse that has taken care of you for the last several months of your life. And that's your choice. It's your property. You can give it to who you want to. Might have some angry family coming after you, but you're dead and gone, and that's okay. It's your property. You can devise it to who you want to. So the opposite of devise is when we have intestate, acquiring ownership through intestacy. When we say intestate or intestacy, this is when you die without a will, right? So you didn't write your formal declaration of what you wanted to happen to your property when you die. You die without a will. And when you acquire ownership through intestate or intestacy, it's called inheritance, right? And just by being related to a person through some kinship, you may have a chance at becoming the owner of some property. So the intestate is governed by each state, right? So Texas has an intestate statute, and basically it's a set of rules that determine who gets your stuff when you die without a will. For example, one of the questions it asks is, are you married? Because if you're married, then certain rules apply to the distribution of your property. If you're not married, they ask you other questions like, do you have children? Because certain rules apply if you have children. And if you don't have, if you're not married and maybe if you don't have children, they ask if you have parents, right? And so then your property will pass to your parents. They may also ask if you have siblings, and certain rules apply and your property may pass to siblings. And so just depends on what kind of heirs you have when you die, if you're married or if you have children or parents or siblings or grandparents or whatever the case may be, your property is going to go to in different directions. So with a will, you get to determine yourself who gets your stuff. If you die without a will, then it passes pursuant to your state statute. So the next way of acquiring title to real estate is through adverse possession. Adverse possession is the legal taking of another's property when you meet certain requirements of a state statute. So basically, you're stealing someone else's land, but you're legally stealing it. So there's certain requirements for adverse possession, and for the most part, they're the same. Some states have different requirements, but you can look at these requirements. Acronym is POACH, right? So this stands for possession. So first, someone has to take possession of property exclusively. It can't be shared with the owner. And after they take possession, they have to use the property open and notoriously, right? So it's apparent to the public. They have to cut the yard. They have to build a fence. They have to do the things that an owner would do with the property uh, that are clear and apparent to the public. Actual, they have to have actual physical dominion and control over the property. So you have to be there on the property. You can't go to the property, build a fence, then leave and 10 years later come back and say, oh, I now own this property by adverse possession because I built the fence, right? You have to be there for the time period. You have to use the property. You have to be an owner and act like an owner and do the things an owner would do. So it has the actual physical dominion over the property. Then it has to be continuous possession for the entire statutory length of time. Each state is going to have different rules. For instance, Texas has 3 different levels of adverse possession, 3, 5, 10, or actually 4, 3, 5, 10, and 25-year possession requirements. So depending on the facts, you can apply for one of those 3, 5, or 10 years, but it has to be continuous for that entire length of time, right? So whatever your state says, it has to be continuous for the whole statutory length of time, that you have to have actual physical dominion and do the things an owner would do open and notoriously, exclusively, not with the owner. And then it has to be hostile. So this just means without consent of the owner, right? So if the owner gives you permission to be on the property, then it's not hostile and you can't become an adverse possessor. So it has to be without the consent. So it doesn't mean a hostile takeover, right? It doesn't have to go in and kick a door down and go in with AK-47s and take over the property. That's not what hostile means in this case. It just means without consent, right? So the owner didn't give you permission. The owner doesn't even know you're there, more than likely. It just means you were there without a right to be, right? So if you meet those requirements, then you can then become the owner of someone else's real property legally. So the Texas statute, this is the definition of adverse possession. Adverse possession means an actual and visible appropriation of real property, commenced and continued under claim of right that is inconsistent with and is hostile to the claim of another person. So you can see in this little definition, you get all of those requirements, right? Actual, visible appropriation, commenced and continued, and hostile, right? So you take possession, it's open and notorious, that's actual, and visible to the public, it's continuous, and hostile. Okay, so the things to take away, you got to know the word title, the term title, and that we're talking about ownership and that we use those terms interchangeably. Know what a gift is, know what devise means and what a will is. Know what intestate is, what inheritance is, what adverse possession, and the requirements. And then absolutely, you need to know from here on out who the grantor and the grantee are. And those terms will be used over and over and over again throughout the course. Very, very important. So that's what you should walk away with. Stay tuned for more on Chapter 1.